I'm Richard Warren from Miller Canfield. I'm a partner in the firm's Employment and Labor Group, and today I'll talk briefly about ways that you can safeguard your intellectual property and confidential and trade secret information and prevent it from being disclosed either to the public or to your competitors. This time of year is the time when you should be particularly concerned with that, because a lot of employees are looking at improving their position or leaving in the first 3 or so months of the year. There's 3 simple ways or methods of making sure that that information is protected from disclosure. And the first is making sure that you limit access within your company to only those employees that really have a need to know it or work with it every day. For example, if your company is in the automotive industry, you would want to take a particular look at items like engineering drawings and highly technical documents to make sure that only the engineers who work with those documents actually have access to them. It would not be a good idea to have everybody in the company to be able to access those either on computer or in hard copy form, because that presents additional opportunities for disclosure, authorized or not. And then as a dual benefit, you also have the ability to convince a court that that information is worthy of protection in the first instance. The second way for you to be able to protect your information from disclosure is through the adoption of a well-written policy that tells employees exactly what they should and should not do when it comes to the company's trade secret and confidential information. That kind of a policy should really have 3 elements. Number 1, it should say that no unauthorized disclosure is permitted. Number 2, it should explain exactly who has access to that information. And then finally, it should require employees to treat carefully confidential and trade secret information and to make sure that that information is always either placed under lock and key in an office or is password protected on a server. And the third and final method of making sure that your trade secret and business information is fully protected from disclosure is to have employees who are in specific positions sign a non-competition agreement that prevents them from even going to a competitor, and in that way you reduce your risk of them taking information and disclosing that information to a competitor in your industry. Now, it's important when you do have employees sign non-competition agreements that they be very reasonable when it comes to geographic scope, where these employees are prohibited from working. Second, also reasonable as to the scope of employment that they are prohibited from working in when they leave you. And then finally, they also need to be reasonable in terms of duration. In other words, how long they're prohibited from working for a competitor after they leave your company. It's also a good idea to consider including in those agreements non-solicitation language